Hello, this is Henry Quillian. I'm at Taylor English Duma with my colleagues. Happy holidays to everybody. We are doing Litigation Fundamentals with Henry Quillian, and this is a tutorial for those out there in the internet world. The purposes of this presentation is to give you things to think about in connection with your litigation. If you're a lawyer, these are things for you to plunge into and decide on your own and help your client make decisions. If you're an unrepresented party, we highly recommend you get a lawyer. And if you decide not to get a lawyer, you better learn this on your own, not rely on what we are saying here, because we're not here to give legal advice. And in addition to that, if you do have a lawyer, ask your lawyer good questions based on what you learned in this session. The topic today is under the Georgia Civil Practice Act, meaning cases of record in courts of record in Georgia. Rule 12 motions. These are motions to dismiss of various types under 911 OCGA 911-12. We will focus principally on motions to dismiss for failure to state a claim, but we will walk through other Rule 12 motions, when they need to be filed, what you need to be worried about in connection with filing any one or more of them, and how to avoid problems where you might step into a malpractice situation by bringing a motion to dismiss, which of course is one thing we try to do here at Taylor English Duma. We try, as a part of this training session, we try to avoid do-overs, we try to avoid stepping into traps, and we try to avoid wasting any client's time or money, and also we try to avoid doing unnecessary work of all types. So, the Georgia Civil Practice Act is what leads the courts in Georgia, the state and superior courts, on the rules that apply to those courts, and it mandates, along with case law, what a litigator can do in order to get rid of a case that has been filed against the client. Now, every client that's been sued that I have, the very first thing they say is, I'm sure you can get rid of this right away on motion because I'm right and they're wrong. Well, sometimes that's true, and sometimes we do. But it's nevertheless a rather strenuous analysis process to reach the determination that one of these motions will actually work to get rid of the case. They might work for other purposes. They might be allowed, and they might get the case transferred to another court. They might get the case transferred or dismissed and has to be refiled in another state. But whether it actually gets rid of the entire case altogether for all time is a whole nother subject matter. So, the procedural stance we would be in this situation, for the most part, is client gets served with summons and complaint process, and they have time to respond. The defendant has time to respond to that complaint. And we've talked about answers and the contents of an answer in previous sessions. One of the things we want to stress is that under the Civil Practice Act, unless you're absolutely positively sure, which you never are, that you're going to win a motion to dismiss, always file an answer timely, because in Georgia you go into default if you don't win your motion to dismiss. Now, under 911-12, which is the applicable statute, it talks about what we are referring to as 12B motions. These are defenses that may be raised by motion and are best raised, but not necessarily only raised, before the time of the original responsive pleading is due. And under 9B, I'll just read the rule and we'll go down through them. There's 7, we're only going to cover really 6 in any detail. We're not going to cover the 7th one very much at all, other than to mention it. And then with respect to the first 6, we'll spend more time on motion to dismiss for failure to state a claim. So it says how defenses and objections presented. Every defense in law or fact to a claim for relief in any pleading, whether a claim, counterclaim, cross-claim, or third-party claim, shall be asserted in the responsive pleading thereto if one is required, except that the following defenses may, at the option of the pleader, be made by motion in writing. So what all does that tell us? It's broad, catch-all. You're supposed to answer and assert your responses and your defenses. You have the option of not answering some types of pleadings. That's not true of the complaint. You always have to answer the sum of the complaint. And then you have the option of making motions along with your answer. Or, if you're really, really gutsy, not filing an answer, but you better have a waiver from your client if you decide to do that. And you can make these defenses by motion if you want to. And they are: 1, lack of jurisdiction over the subject matter; 2, lack of jurisdiction over the person; 3, improper venue; 4, insufficiency of process; 5, insufficiency of service of process; 6, failure to state a claim upon which relief can be granted; and 7, failure to join a party under Code Section 911-19. It goes on to say, a motion making any of these defenses shall be made before or at the time of pleading, if a further pleading is permitted. Note, but then there are other sections of the rule that address whether a waiver actually takes place if you do not make your motion at or before the time of pleading. The general idea, courts like having matters that are presented to them brought into issue and decided early. So they encourage, by that language, that the motions be made at or before the time of pleading. No defense or objection is waived by being joined with one or more other defenses or objections in a responsive pleading or motion. So let's say you had a lot of different grounds that you wanted to make a motion on. If you put them all in one motion, you're not waiving any of the other ones by making one of your motions. If a pleading sets forth a claim for relief to which the adverse party is not required to serve a responsive pleading, he may assert at the trial any defense in law or fact of the claim for relief. And then if, when a motion to dismiss for failure of the pleading to state a claim upon which relief can be granted, matters outside of the pleadings are presented to or not excluded by the court, the motion shall be treated as one for summary judgment. And we will bring that up later. But basically, what we're focusing on here is something that starts off as a motion to dismiss and stays a motion to dismiss. So, as mentioned at the very beginning, there may be cases in federal court that apply more restrictive standards on the pleading, the initial pleading of the complaint, than does the Civil Practice Act. The Civil Practice Act is not adopted by case law or by statute some of the additional layers of analysis that federal courts apply. So if you're a lawyer or somebody trying to figure out whether a motion to dismiss should be granted, just be aware the federal courts might require the pleader to do more than the Georgia courts do. But as we've already mentioned, there are certain things that have to be in the complaint, which including, for instance, an allegation of facts upon which venue can be founded. And as we note, one of the things that you can move to dismiss on is improper venue. So I saw a couple of hands about to go up. Julian?
So is the Georgia rule the same rule number as the federal rule? Is that just to confuse us?
Yes. Yes. The Georgia Civil Practice Act was modeled after the Federal Rules of Civil Procedure. As far as the numbering system goes, of course, we've got the 9-11 to start with. But then case law in the federal courts has added additional layer of analysis. So the Georgia courts have not adopted. And
I guess the other point too is that the federal rules are amended every couple of years, and the Georgia legislature doesn't necessarily try to keep up with those. I think the board has to keep up with those.
That's right. So let's put it this way: the federal courts are probably more nimble in changing civil procedure rules than is the Georgia legislature, which may not want to ever look at the Civil Practice Act, but probably is forced to by some lawyers somewhere along the way, especially if the lawyers realize that the legislature mucked something up so badly it needs to be fixed. And so the state bar might take it down there to the legislature and get something changed or fixed. And in fact, there have been changes in the Civil Practice Act in the last 6 or 8 years. Okay, so you've got your complaint, you've got your time to respond, and you've got to figure out whether it's a good thing or a bad thing. Despite the fact your client thinks the case ought to be thrown out immediately no matter what, to spend the time and effort to prepare and file a motion to dismiss on one of these various grounds. And some of these motions require you to come forward with evidence, and others constrain you to only looking at what's in the complaint and the attachments there too. So you've got to determine, okay, if I break this motion, am I going to be spending more money than it's worth to get rid of this case? Some motions you can file, and we'll go into a minute, can actually end up costing so much money by the time you fight out the motion that the whole case could have been settled and paid for by the time you address the motion. And so you want to avoid a circumstance where, in order to try to get rid of the case by motion, you spend more than the case is worth. In fact, before you answer, or at the time you answer, and before you file a motion to dismiss, what should you talk to your client about possibly doing rather than litigating the case to the hilt?
Mediation?
Could be a mediation, yeah, where you call up the other side. Anybody else? Yeah, so settling, that's what a mediation, what you hope mediation leads to, right? So it may be you look at the complaint, you look at what the facts, you look at what the client agreed to do, or whatever the case may be, what the client actually did, maybe decide to get it settled before anything goes forward. Sometimes you know your client has some information the other side does not yet have, and it will be terrible for your client if they go into discovery. And sometimes the opposing side has much lower expectations than they should regarding the case based on what you've learned from your client. And so it's a good thing to go forward and get it settled. I actually had a case that literally I was afraid my client would be liable for tens of millions of dollars based on what they had done under a federal statute. And we got it settled for $17,000 before the answer was filed. Because the plaintiff had low expectations, they didn't want to fight it. We knew things they didn't know and we weren't about to tell them because we hadn't gotten to the point where we got into discovery. And they took the money and ran, and of course, literally within seconds after I got off the phone with the plaintiff's lawyer, I sent an email that confirmed the entire settlement and nailed it down. Evaluate whether you need to make a motion at all, whether you want to fight this case. Okay, so then you got to look at the absolutely fundamentals of the litigation, the foundations of the lawsuit. And the first one under Rule 12 is subject matter jurisdiction. Did the plaintiff bring the case in a court that they can even be in for what they are claiming? Now, we have basically 3 levels of trial courts in Georgia, which are a lot of counties have magistrate courts, which have very limited jurisdiction. And then we have the state courts of the state of Georgia, which are basic civil courts. And then we have the superior courts that have broad, equitable, and civil powers and jurisdiction. So, with respect to subject matter jurisdiction, is the case in the correct court? Now, I believe as between a state court and a superior court, if the court case is filed in the wrong court, there will be a transfer from state to superior. If somebody brings from state to superior. If they bring a claim that's not appropriate for state court, then you get transferred over to superior. Does that ring true? I think that's true. But if they bring a federal action, let's say they bring a patent infringement case in state court, then you can make a determination whether you want to move it out of the court altogether or get dismissal for lack of subject matter jurisdiction because it's exclusive jurisdiction in federal court. But in this instance, with respect to lack of subject matter jurisdiction, let's say it's just some subject matter that there is no court that will address this thing. You can consider a Rule 12b-1 motion. This would be a filing that is based on what's alleged in the complaint, and you say, this court just doesn't have power to address this subject matter, we want to dismiss. They brought solely a copyright litigation in the Superior Court. Move to dismiss, lack of subject matter jurisdiction. The second one is lack of jurisdiction over the person. Well, this is a situation where the defendant basically claims that under the Constitution of the state of Georgia and the Constitution of the United States of America, as well as under what's called the long-arm statutes of Georgia, meaning the authority given by the legislature for plaintiffs in the state to reach out and to sue people from other states. It's basically a claim that it's unconstitutionally unfair for this particular defendant to have to litigate in this particular court because mainly it's for reasons that they never came to Georgia, they never had anything to do with Georgia. The case is brought in Georgia solely for the convenience of the plaintiff, and this person has never come here, never did anything here, should not be subjected to a lawsuit in Georgia.
You
Now,
remind
this
me
is the
of
one.
a case called Panoia versus Neff. I think I learned my first year of law school about 100 years ago.
Yeah, 100 years ago, and the case is more than 100 years old, I'm pretty sure. This is the type of thing you learn in law school, and you wonder what in the world are they hitting you with when at the very first couple of weeks of law school. But my point here is, yes, you might want to make a motion to dismiss for lack of personal jurisdiction over the person, but you need to consider whether you want to do that because, as we will see, under Rule 12J4, the plaintiff can immediately open up discovery on your client since you're the defendant. If you make a motion and come forward, let's say with an affidavit saying, by your client saying, I was never in Georgia, never did anything in Georgia, etc. And then the plaintiff says, well, that's not what I believe. And so they seek discovery on that issue. And then they find out that, indeed, you were in Georgia, you just had a mistress in Georgia, you didn't want to tell your wife about it, whatever. And there may be all sorts of other subject matters you don't want to open the book on that the plaintiff, yes, can investigate into regarding your involvement with the state of Georgia if you file a motion to dismiss. And if they do discovery, what does that mean for lawyers? It means work. And if it's work for lawyers and you're the defendant, what does that mean? Fees. And if they're fees, that's expense. And so literally there are cases where you can spend hundreds of thousands of dollars litigating over whether the defendant can be sued in the state where they got sued. That happened in a patent case where a big corporate conglomerate question was whether this particular parent company, which is very old, very long standing, had adequate contacts with the state of Georgia through all these different subsidiaries to be in the courts of Georgia. So consider whether you open up that can of worms before you make a motion to dismiss for lack of personal jurisdiction. Yes?
So, I'm the corporate guy, so I apologize for the fundamental nature of my question, but we're drafting all of these choice of venue clauses in all these agreements. So under a contract action, I mean, how enforceable is that? How ironclad is that if I've got someone, well, you agree to be, we're going to get dismissed in one jurisdiction because they agreed to be in this other one, even if the ties aren't very strong.
Okay, so the question is how enforceable are contractual provisions presumably entered into by the defendant saying, I agree to be sued in this particular venue, in this case, Georgia, no doubt, and that they've gotten sued in Georgia? That's the hypothetical. They got sued in Georgia. Is it enforceable in Georgia?
Or maybe they're getting sued in California, but we want to move it to Georgia.
Okay. So it depends on the law of the state where they actually did get sued.
Okay.
And so, I don't know, we could have a showing of hands, but how many believe that 2/3 of the states will enforce a contractual choice of venue clause? I think that 2/3 of the states will do that. We learned recently that North Carolina, 2 or 3 years ago, passed a statute that said they won't enforce a choice of venue clause that requires a North Carolina resident suing an out-of-state party who otherwise would be subject to jurisdiction to go to another state to bring the lawsuit. So you can have provincial statutes that protect the party, usually it's the citizens of the state where the lawsuit is brought. But I think probably at least 2/3 of the states will enforce the choice of venue clause. But if you're dealing with North Carolina, be aware it might not work. I have one client that literally sends all of its cases to a colleague of mine down in Florida. No matter, and they're all over the United States, and for the most part, all the cases get funneled to that law firm in Florida, no matter where the lawsuits are brought. So that's good for my friend. Okay, so just be aware that you can get into a lot of nitty-gritty things that have nothing to do with the lawsuit that otherwise wouldn't be within the scope of discovery. Because the issue is it fair for this person to be sued in this state? Then a lot of things that entity or person might have done in the state all of a sudden become relevant to the lawsuit, which otherwise wouldn't be relevant at all, and a lot of money being spent. Okay, 12B3 motion is one for improper venue. We discussed this briefly in a previous Quillian's kernels, Litigation Fundamentals, and we talked about how the complaint itself has to plead facts to support venue. So what if a citizen, an individual person in Georgia gets sued in a county other than their own home county? Should the party make a motion to dismiss for improper venue? Well, I see some no's.
I think so.
What if you hate the judge in the county where you're getting sued?
That turns into a transfer motion.
Aha! So, Mr. Virgin points out that under Georgia law, if the venue is improper in the county where the lawsuit is started and a motion to dismiss for improper venue is brought, and there are allegations of fact sufficient to at least allege venue, then it would get transferred to the correct venue. In other words, another county in Georgia. That's the remedy that the courts state is to happen. However, if there are no facts associated with venue, a motion to dismiss for improper venue could be granted if the plaintiff does not come forward with anything that says where the proper venue is. In other words, the defendant comes forward and says, I'm not a resident of this county, and that's all they say, and nobody proves where the proper venue is, and the court could dismiss the complaint. So that one might be worthwhile. Usually it's just a matter of moving it to the other venue, and of course, if you're the defendant, you always got to consider, do I want what I'm asking for? Am I asking myself to be thrown into the lion's den when in fact I would be in the mouse's den in the county where I am? So it doesn't always do you good to change things up if you're the defendant. Sometimes you're in a wonderful position right where you are. And by the way, since we're really talking about fundamentals, what is a motion? How does it come into existence? Where do you put it in order to make it a motion? Okay, it's a pleading that has got words on it. And it's, where is it filed if you want to make a motion before a court? You file it at the clerk's office or using electronic filing, this is now required, right? So when we were talking about fundamentals of litigation, and what does it have to say in it? What does a motion have to say in it?
Usually you cite the rule that you're moving under, and you request the relief that one or more counts be dismissed pursuant to that rule.
Okay, so yeah, you have to state who you are, what you want, and it has to, and generally speaking, it has to somehow or another communicate to the court that you're making a motion, which could be a request for relief or actually I move for this, and then state the basis for your motion. And then what are you required to do in Georgia if you file a motion?
Sign it.
You're supposed to sign it if you're either a pro se litigant or a lawyer. And what else are you supposed to do with the motion? Well, you might have to pay the fee to file it, especially if it's electronic. Some counties actually require you to pay a fee. It used to charge a fee for filing papers in addition to your complaint submission. Well, you have to file a brief, which is generally could be part of the motion, same document, or could be separate. But one way or another, the Uniform Superior Court rules require you to file a brief that sets forth the legal basis for your motion. That has to be signed, and all this has to be served on the other party, right? So that's just going back to the basics. What is a motion? How do you get there? What has to be on paper? An electronic paper, I guess, these days. Okay. So with respect to improper venue, that may or may not get you out of court altogether, but it might get you in front of a different judge. And sometimes a client can be told by a lawyer, correctly or incorrectly, lawyer to the judge or before is terrible. Let's see if we can come up with a reason to get over to a different court. Okay, insufficiency of process. We talked about that briefly regarding the Stamps case. That would be where you don't have the summons attached to the complaint. If you're a defendant, you just get the complaint, no summons, which would be insufficient process because the summons and the complaint together constitute the process, right? And so, and it could be you have a summons, it's not signed by the clerk or something of that nature, but you need to examine your documents as a defense attorney, figure out whether there's anything defective with the lawsuit that's been served such that it's not even competent as a lawsuit. It's not signed by, well actually probably signing, I don't know if that makes an insufficient process or not, I doubt it does, but definitely if you're missing the summons, it would be insufficient process. You move to dismiss under Rule 12b4. All right, a fun one, which we do use, is insufficiency of service of process. And again, we can spend a whole day on what is adequate service of process against any particular type of entity within the state of Georgia of the Civil Practice Act. We do that a different day. But that's basically, you have to get the complaint and summons into the hands of the person who you're suing or the entity that you're suing in a proper way and before a proper person. And so the example I can't think I gave earlier is we had a client who was 6'3". She learned about a hearing. She went to it and said, they never served me with the lawsuit in this matter. And the affidavit of service that the process server had signed said something like, you know, it's a 5'2" person. And so the judge looked at the defendant, looked at the affidavit, said, all right, no way this is a correct, this is sufficient service process because it's clearly the wrong person. Case gets dismissed. Otherwise, you have all sorts of examples. Lawsuits that just get stuck on the door that need to be handed in person. Lawsuits that are thrown at people who never caught them. And one of the fun ones is, you know, you got a gated community. The defendant drives out, the person jumps out of the bushes, slams him on the windshield. You know, is that good service of process? Well, we can go into that later on, but nevertheless, it's a situation where the defendant has to come forward and either attack what's on record, the service that's been prepared and filed by the plaintiff's lawyer or by the process server, and then, or they have to come forward with affirmative evidence saying the lawsuit was left at the front door, but the right person never handed the lawsuit, so you can't continue to pursue this lawsuit. The problem with this motion is what? Is it going to get rid of your case forever and all times? Most likely. No, because they can come back and start again unless, what we were talking about at the very first renewal of Quillian's kernels and litigation fundamentals, unless the statute of limitations is at the end of the statute of limitations and the plaintiff's lawyer can establish that they were use reasonable diligence in trying to get proper service. So the statute of limitations runs. Or, what can happen to your defendant if you serve it wrong and then they learn about the lawsuit? They can just disappear, yes. So I had a great lawsuit once where it was a construction lawsuit. An individual, why they had it set up this way, I don't know, was running a construction project. He was running it, he was the registered agent for his corporation, which was responsible for building an entire food processing plant. And after he didn't pay the subs, he got into a fight with his girlfriend, and the police came to the house. The house was full of marijuana plants. The guy disappeared, never seen again. He went to the Bahamas or someplace, leaving all sorts of plaintiffs with a very difficult time serving the corporation until such time as they ultimately used the mechanism where the Secretary of State was served, including my client. But people do disappear, and so that's something to always take into account. If you're a plaintiff's lawyer, we need to go ahead and get this thing filed now where we know where the defendants are and how we can get a hold of them. Okay, so that's insufficiency of service in the process. Okay, failure to state a claim. Famous 12B6 motion. Who's heard of the word 12B6 before? And who talks about 12B6 to people at cocktail parties and they have no idea what you're talking about? All right. A 12B6 motion under 911 12 parens little b parens 6 is a motion for failure to state a claim upon which relief can be granted. So, if you're a defense lawyer and you get the lawsuit, what do you have to do to figure out whether a claim has been stated upon which relief can be granted?
Consult case law for elements of the claim or statute.
Yeah, what would be the first thing you do as a defense lawyer? You would read the complaint. Yeah, you would read the complaint. You would see whether it actually says anything. If it just says, "Hi, signed lawyer," that doesn't state a cause of action. But then you would go and do some research on whether the thing that you understand and believe the plaintiff is trying to assert against your client actually stacks up to the law that it must stack up to in order to ultimately state a claim. So for instance, if it says the defendant negligently ran through the red light, but it never says plaintiff was injured, never says any damages happened, then the elements of the claim are, duty, breach of duty, injury, and there's no injury alleged, then the plaintiff has failed to state a claim upon which relief can be granted. There's also one some cases are easy to allege because you can just say this happened and it's obvious that the claim would exist as a result. Michael alleges that Henry punched him in the face, and it's a battery claim, and that's probably all that has to be stated because it's implied that damages would occur, etc. However, there are other causes of action with a whole lot of elements, and so if the defense lawyer learns or considers looking at everything that's within the complaint and assuming everything is stated, every single word is true and can't be contested, and finds that there's a missing part of the complaint or the cause of action that the plaintiff is trying to assert, then the complaint might be subject to dismissal. So let me just read what the law actually says regarding the standard for a motion to dismiss under OCGA 911-12b-6. The allegations of the pleadings disclose with certainty that the claimant would not be entitled to relief upon the provable facts asserted in support thereof, and the movement establishes that the claimant could not introduce evidence within the framework of the pleading sufficient to warrant a grant of relief sought. So, is that a standard that's favorable to the plaintiff or favorable to the defendant? Just out of the box. It's favorable to the defendant. It's very liberal in favor of the plaintiff. So I may have said something wrong. It's favorable to the plaintiff. It's not good for the defendant unless the defendant can show, based on what's pled, that something's terribly wrong. So let's give an example of something that might be terribly wrong. The plaintiff moves to dismiss because the complaint clearly says something happened in 1900. A tort claim happened in 1900. What would be clearly wrong with that complaint? Statute of limitations. Complaint alleges that somebody else other than the plaintiff got injured, and that the plaintiff has no basis to recover on behalf of that person. They've alleged the wrong thing. And that does happen, by the way, sometimes in plaintiff's mills. They just forget to change the names on the documents, right? So you never know what's going to happen. All right, now how about this one? This one actually came up yesterday. It's actually on file. Mechanics lien, which is a lien that can be filed of record to help a subcontractor or supplier collect. The law requires that the notice of claim that's sent to the property owner is in 12-point type. But the complaint has attached to it a document, and the complaint says it's a true and correct copy of the notice of claim, and it looks like microfiche. Can you move to dismiss based on something that's attached to the complaint? Yes, you can. And why is that? Under Rule 10C, I believe that's correct, 911-10C, the exhibits to a complaint are considered to be a portion and fully adopted within the complaint. So it is 911-10C. Statements in a pleading may be adopted by reference in a different part of the same pleading or in another pleading or in a motion. A copy of any written instrument, which is an exhibit to the pleading, is part thereof for all purposes. So, if that's the case, and the complaint says, and has exhibits, and it says this is what happened, this is what I did, this is true and correct copy of this, it's attached to Exhibit A, and Exhibit A is something that totally undermines the legality of the claim that's being sought. Could be a release. I don't know why any plaintiff's lawyer would attach that. Or it could be a note that's written or issued by the different person other than the plaintiff, or whatever. Then you can move to dismiss based on what is said in the complaint. Now, can you go outside the complaint? Yes, ma'am.
I just had a question. Assuming that it's a technical issue, it's not a statute of limitations type of thing, but it's the wrong document, or they didn't allege a certain element of the claim, is there anything to prevent the plaintiff from simply amending their complaint after you file the motion to dismiss to defeat your ability to succeed in your motion to dismiss?
Okay, so the question, just in case it wasn't heard on the video, is can a plaintiff who has been faced with some problem with their complaint simply amend their complaint under the Civil Practice Act in order to fix the problem? And the answer is yes, if it's fixable.
Right.
So for instance, in my case, could they, or the case that I just mentioned, can they make the notice that they earlier sent in bigger type than it actually was? No, they can't go blow it up on the printer and make it bigger than it actually was and say, now that's the notice, not what I originally said was the notice. And that is something to take into account when you're moving to dismiss. If it's so easily fixed, it may not be worth the effort and the time and the expense to your client. If it's something that can't be fixed by way of additional allegations that are possible, then you might want to move to dismiss. So for instance, if the plaintiff has boxed themselves in to an extent that you know that they cannot truthfully come forward with any allegation that's going to fulfill the missing element of the complaint, then that would be a good motion to dismiss to file.
You know, Henry, I think on your material misleading example, if you file your complaint inside the 90 days, they could refile the lien inside the 90 days, dismiss the complaint, and refile it again.
Okay, well, that would be a theoretical situation that doesn't exist.
That's probably true, but if it does exist,
We won't post this for 30 days.
delay filing the answer. Delay filing the answer until.
That's true. The other point on that one is that you could probably only dismiss the lien foreclosure claim, but not the breach of contract, underlying breach of contract claim.
Yeah, well, we won't. Who wants to talk about mechanics lien law?
Just the construction attorneys.
Come back next time. Yes.
How many times can you amend your complaint in Georgia? Do you have to get permission from the judge every time?
Okay, in Georgia, we're getting a little bit off topic here, but until you actually have a pretrial order entered, you can amend your complaint. And there have been cases that I've had. I start off here, go through discovery, learn something new, add a claim, go through some more discovery, learn that everything that was told to my client was actually false or whatever, add another claim. And you know, in my practice, if I'm doing a RICO claim, lots of times I'll bring a vanilla lawsuit that I believe ultimately might be a RICO claim, but I'm not going to bring it out of the box until I actually have all the evidence I need, and then you suck it to them. But what you do need to worry about forward-looking, if you're entering your pretrial order, you better make sure you cover all your claims and everything you want to assert at trial, because after that you would have to get leave of court to amend your complaint. Federal court, different. This is not federal court. Okay, so on a motion to dismiss under 12b-6, you're constrained to what it actually says in the complaint, and under this standard, you have to say that there is, the pleading discloses with certainty that the claimant would not be entitled to relief under the provable facts asserted in support thereof. And then, in ruling on a motion to dismiss, the court must construe all allegations in the complaint in the light most favorable to plaintiff and resolve all doubts in favor of plaintiff. So, you only want to make a motion to dismiss for under 12b-6 for failure to state a claim if you're pretty darn sure that you can knock the complaint out. But it doesn't hurt, as Mr. Cicero and I were talking about earlier. You've got a really complicated matter, and there's some credit to, if you know you can move to dismiss and yet they can amend the complaint, you might do it anyway. Start training the judge up on an area of law the judge might not know anything about, especially if you think at the end of the day you're either going to win summary judgment on that law or win at trial, or the plaintiff won't be able to sustain their cause of action, because you don't necessarily want to get to trial and have the court thinking through the law of the case for the very first time when you're making a motion to dismiss or making a motion for a judgment notwithstanding the verdict or whatever. You want them to actually know what the law is so they can say, oh yeah, I see, they never did actually prove that element. Even though they talked about it in the complaint, they never proved it, so you win after all. And you can always study the attachments, because sometimes the attachments completely cut off at the knees what the plaintiff is suing for. They might only take out part of a claim. Let's say they allege a contract and breach of contract, and they allege all sorts of consequential damages as the damages they want as a result of the breach of the contract. Yet the contract they attach has an express, clear waiver of consequential damages provision in it. And they're saying that's the contract we're suing on. You might just move to dismiss only the consequential damages claim. That might make the plaintiff say, well, gee, now this case isn't worth it if we can't recover consequential damages. Bring you to settlement really quick. Generally speaking, courts do not like to grant motions to dismiss for failure to state a claim, but they will do it. And this gets to a point that I don't want to overlook. So if you make a motion to dismiss, we've already talked about the fact you can move to dismiss on all the grounds you have available to you when you do file a motion to dismiss. But if you do make a motion to dismiss, you want to make sure that you do raise certain defenses that you're not planning on actually bringing up later. And that's under 911-12H. A defense of lack of jurisdiction over the person, improper venue, insufficiency of process, or insufficiency of service of process is waived. A. This is H1A. If omitted from a motion in the circumstances described in subsection G of this code. Subsection G says you may need to make all motions that are available to you based on the circumstances at the time when you file the motion. So if things have occurred that would give you the right to make the motion, and you fail to make the motion, then you can waive those three different bases for moving to dismiss. And it says, if it is neither made by motion under the code section or included in the responsive pleading as originally filed. Which means what you have to raise is affirmative defenses within your answer. Well, at least those three affirmative defenses: lack of jurisdiction of a person, improper venue, insufficiency of process, or insufficiency of service process. I guess that's four. Those have to be raised in your answer. Otherwise, you have the risk of losing them down the road if you fail to, make a motion to dismiss. Now, I actually had a case, bring that home, and this shows a tie between 12B6 motions and 12B 1, 2, 3, 4 motions. Sued a bunch of entities, including companies all over the world that happen to have a presence in Georgia. One of the claims was intentional infliction of emotional distress. Got the person in Georgia that was believed to be associated with all these companies all over the world, sued and served all the companies under the assertion that that was the proper person to serve when processed. All the defendants moved to dismiss intentional infliction of emotional distress claim. In Georgia, intentional infliction of emotional distress has an extremely high standard if you're a plaintiff. Basically, you have to allege that the actions taken by the defendant were outrageous and totally unacceptable in the civilized society and caused severe harm to your plaintiff, usually only shown by hospitalization. And so lots and lots of things you have to allege, and you have to be able to allege truthfully if you're going to comply with your 9/11 requirements. The defendants didn't move. When they moved under 12B6, they didn't move for their lack of jurisdiction over the person. And then they came back later and they tried to move to dismiss the companies that were across the world for lack of jurisdiction over the person. We said, no, they waived all those. They filed a motion to dismiss earlier. We got to keep them all in court, which was very, very good. So you don't want to look at one thing without looking at the whole spectrum of things you need to do now if you're going to ultimately assert. If you're going to make a motion, make sure you include in it what you do have to include. Okay. You make a motion, the last one was failure to add an indispensable party. We're not going to cover that, too complicated. So what happens if you make a motion to dismiss in Georgia and you file the motion to dismiss before or at the time of filing the answer? Can you immediately start depositions?
On the issue raised in the motion.
Okay, only if it's a 1, 2, 3, or 4 motion, right? If it's something where the plaintiff has the right to get discovery in order to try to overcome the motion to dismiss, then discovery can be taken. But what otherwise now happens under Rule 12J? Is it stay for how long?
So the motion's
It's
decided or sometime.
It's the earlier of 90 days or when the motion is decided. So, and it actually says the court is supposed to decide the motion. The court shall decide the motion to dismiss within 90 days provided in this paragraph. How many times does that happen? Sometimes it does, rarely does it happen. So what that means is during the time motion to dismiss is if one is filed timely, then everything, basically, all the discovery is stayed and all the deadlines are extended accordingly. But if the court rules, then all of a sudden and denies the motion, discovery gets started right away. Or if the court doesn't rule and 90 days passes, discovery starts. And so the general idea there, if your motion is so good that you're going to get the whole case thrown out, why spend a ton of time during discovery? But there may be reasons why you want discovery, and so you might not file your motion to dismiss within that first time frame. So consider that as well. If you're the defendant and you want to actually know what the goods the plaintiff allegedly has, you might not want to move right before the answer if you don't have to, because you might want to actually take discovery. Okay. We talked about earlier if there's something other than the complaint you're referencing. Let's say your client says, well, I know I've got this release. I want you to get rid of the case. You need to move to dismiss this case because even though the plaintiff is suing me for this tort, I got a release and I paid the money for it. And you come back and your motion, quote, motion to dismiss, and supply a copy of the release and the canceled check. What happens to your motion to dismiss? Yeah, it gets converted to a Rule 56 summary judgment motion, which in turn, if the plaintiff wants it, gives the opportunity to the plaintiff to do what? Take discovery on those issues. So just be aware that if you want to keep it in the realm of motion to dismiss and don't want to have discovery, don't add anything to your motion. Just stay within the four corners of the complaint and all the attachments. Now this is one that's not discussed a lot. What if the complaint has an exhibit and it's a release and the complaint says Exhibit B here too is a release purportedly signed by the plaintiff, but the plaintiff didn't sign the release? Can the defendant win the motion to dismiss based on the release? The answer is no. So just the fact that the exhibit is there doesn't make it mean exactly what only the exhibit says. You have to look at the complaint and the exhibit together. Okay. Any other questions you want to discuss relating to motions to dismiss? The first level of the motions to dismiss.
Just one nuance. The difference between state and federal court is there's not a federal court section that's comparable to the stay of discovery provision in the Georgia Code. So if you file a motion to dismiss in federal court, you don't have to answer, but if you file just a motion to dismiss, in the Northern District of Georgia, discovery doesn't start until 30 days after the answer is filed. But you have to have a Rule 26F conference and file the joint preliminary report. All that is triggered by answer or motion. So
Okay.
none of that is stayed automatically. So typically what we do is get the other side to agree and file a motion, a stipulation or a joint consent motion to stay the requirement to have the 26F conference and file the joint preliminary report until after the motion to dismiss is ruled.
Okay, so essentially you get the judge to say, the rules say this, but we're gonna set all this aside into the future until we decide the motion to dismiss.
Yes.
And that might be good, because what if you get rid of 3 out of the 4 claims, and with your motion to dismiss, all of a sudden you have to talk about a whole lot less at all those conferences,
Exactly.
plan for a lot less discovery. So make sure you get your lawyer, and if you're evaluating a complaint, consider a motion to dismiss. Take your opportunity to figure out what your case is, where your defenses are, and where your liabilities are. Decide whether you should settle, decide whether you should move to dismiss, decide whether the motion you want to make is going to cost you more than it's worth, and then make sure you file it properly and timely if you do pursue it, and that you don't omit things that you need to include to avoid waiting. Thank you.